Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a very important webinar on getting paid faster with liens, bonds, and contracts in the state of Louisiana, conducted by Ted, who is an absolutely brilliant expert lien law, bond claim law attorney, and I have to add, an exceptional artist too. So without further ado, I'd like to introduce Ted.
Hey, good afternoon. Well, as Ariella said, my name is Ted Laperouse, and I'm an attorney with Laperouse APLC in Baton Rouge. This webinar for SunRay is intended as a basic primer for contractors and subcontractors in Louisiana on the use of contracts, liens, and bonds to receive payment for your work. As in most states, it's important in Louisiana when bidding and working in the construction industry to ensure that you have a binding contract in writing. And for some of you, that may sound fairly simple, and probably for others, having a written contract may actually sound difficult or a bit of a headache. But I'm here to tell you that whether you're a home builder or a contractor or a subcontractor, having a written contract can be the difference between being in business and losing your business. And being in writing is the key. So what is a contract? Obviously, a contract is an agreement, but a contract can be both oral or in writing, and they're both enforceable in court. And a contract is essentially the law between the parties for that particular transaction. And that's why it's important to get it in writing. Because when a problem starts to develop, if it's not in writing, memories about what was agreed to can fade, and you might be stuck trying to prove what the law is between the parties without any evidence of it. There's a lot of he said, she said that never plays well in court. So what types of terms should be in your contracts? Well, things like payment terms and, excuse me, I haven't been doing the PowerPoint, but payment terms, scope of the work, you need to know what type of work you're doing, timing deadlines, and those are the obvious ones. But what about your ability to stop work as a contractor or leave the project if you're not timely paid? You may also want to include things like compensation if you're forced to stop work and wait on direction from the owner, or if you're delayed, or that any extra or change order will be performed only if there's a written change order to go along with it. Why? Because if you don't require a written change order for additional money, the owner or contractor may take the approach that it should have been included in the original price and they won't pay you for it. Remember, memories fade, especially when money's at stake. So what about attorney's fees? Some of you may know in Louisiana that if you don't provide in your written contract that you're entitled to recover your legal fees, if you're forced to sue on it, you may not be able to recover them at all, and attorney's fees are expensive. Attorneys like me routinely help our clients draft and negotiate contracts and service agreements, from everything like simple installation agreements to master service agreements to multi-million-dollar project contracts. You know, we work with you to develop the types of agreements that may be unique to your business and cover the types of things that are important to your particular company. Don't be discouraged, even if your business is traditionally one where you may not have a written agreement. You should still try to implement the process if you can. So contracts provide the law, and just as they provide the law as agreed to, they provide the remedy or cause of action that's enforceable in court when someone breaks one of their contractual promises. We lawyers use the term breach of contract because that's what the legal cause of action is when we sue on your behalf the party who breached or broke the agreement, such as when you don't get paid for your work. So that's just a quick recap of the of contracts and why they're so important. It is important, again, to get it in writing, and so that when you do have a problem, everybody's on the same page and the court can enforce what the parties actually agreed to. So we talked about the claim for breach of contract when somebody breaches, but in Louisiana, like most states, the law provides to contractors and subcontractors like you who perform work on somebody's construction project a special or secondary remedy in addition to your claim for breach of contract. So this is where we talk about liens. What is a lien? A lien is a claim to a property right that attaches to the piece of property that you performed work on. So in addition to the claim for breach of contract against the company who had an agreement with you and breached that agreement, whether you're a contractor, a sub, or supplier, and whether or not you have a contract with the owner, you're still granted special rights to lien the project to secure payment. It's like collateral. You built this great building on this piece of property, and the law says that because you enhanced this property, we're going to allow you, if you're not paid for enhancing that property, to use the building to ensure that you get your money. And if you're successful in suing to foreclose that lien against the piece of property, ultimately, in theory, the court commands the sheriff to seize the building and sell it at judicial sale and remit the proceeds to you to satisfy the debt that's owed to you. Practically, that may never happen because an owner will likely, in 99, maybe 999 out of 1,000 times, choose to pay you to prevent his building from being taken by the sheriff and sold. But in theory, that's what a lien does. A lien is a claim to a property right that allows you to foreclose on that property to satisfy your debt. So liens are an important remedy granted to builders and contractors and subs like you. And so because this remedy is so extraordinary and can encumber property of somebody that you may not have even had a contract with, the law also makes you jump through some pretty significant hoops in order to protect your lien rights. They're both time deadlines and content requirements for your lien claim that must be strictly adhered to, or otherwise you can lose your lien rights. The law basically says that if we're going to give you this right to go after an owner's piece of property where that owner didn't even contract with you, we're going to make it tough for you to do that. And we're going to make sure that that owner has lots of notice so that he can avoid getting his property encumbered with your lien. But because of the timing deadlines and the content requirements, if you have a lien, I recommend that you use an attorney or a service like SunRay to assist you with filing one. Because even if you miss one little thing, you could lose that important way to collect. Similar to lien claims are bond claims. And a bond claim is instead of the lien attaching to the owner's property, especially on public jobs, a surety bond, a payment bond is required, but also on private property, an owner can require the general contractor to furnish a payment bond, in which case your lien doesn't attach to the property, but it rather attaches to the surety bond. And the surety bond takes the place of the collateral that the property ordinarily would serve as collateral. The surety companies are typically related in some way to insurance companies, but they're not insurers. They are sureties, which is different. And so they essentially guarantee the debt of the general contractor or a sub to their downstream partners who help them construct the project. Similar to lien claims, though, there are also some hoops that you have to jump through in order to perfect a bond claim. And again, should you have a bond claim or a lien, I would highly recommend hiring SunRay or an attorney to help you make sure that your content is proper, that you're timely, and that the claim is properly filed if it needs to be filed. So how do you know whether a bond has been filed? Similar to, and this also applies to getting the legal description that you will need for your lien, but Louisiana law requires that in order for the owner's property to be protected from lien claims by a bond, the payment bond must be filed along with the contract or the notice of contract before starting work. And if it's not filed before work starts, if it's not in the proper format, if it's not in the proper amount, then it doesn't serve to remove the owner's property from being liened or subject to a lien. And again, you or your attorney would need to check the property records for the parish in which you performed that work. So let's talk about just a couple of required notices and important deadlines and requirements for lien claims. For general contractors, in order to have a lien claim, you must file a notice of contract before work begins. Otherwise, you completely lose your lien rights. And I should also add, a general contractor will not have any claim on a payment bond because the general contractor is the one who actually procures the bond for a price. So the general contractor on private projects would still have a lien claim. On public projects, there really is no security like there are on private jobs because you can't lien a public building or property. Subcontractors. There's several different deadlines and a lot of them can be confusing, but it depends a lot upon whether the general contractor files what's called a notice of contract and also whether they file a notice of termination. Sometimes in more typically, the notice of termination is called a notice of substantial completion. But generally speaking, a subcontractor will have 30 days from substantial completion to file a notice of to file a lien if a notice of contract has been filed. Let me say that again. Generally speaking, a subcontractor will have 30 days from substantial completion of the entire project to file a lien if a notice of contract was timely filed. If a notice of contract was not timely filed, the subcontractor will have 60 days after substantial completion to file a lien. Second tier subs. So in order for, if you've got a contract with a subcontractor and not directly with the general contractor or an owner, you are also required to send notice to the owner and the contractor of your claim for non-payment at least 30 days before filing a lawsuit. Suppliers, you have even more onerous requirements in addition to the normal lien requirements. You have to send notice of non-payment to the owner and the contractor within 75 days after the last day of the calendar month in which your goods were furnished. Let me say that again. If you've got to in order, if you're a material supplier or a vendor, you have to send notice of non-payment to the owner and the contractor no later than 75 days after the last day of the month in which your goods were furnished. And if you furnish goods in several months, you should send notice by the deadline for each month that you're not paid. Companies who rent equipment, if you're on the line, you've got to provide notice to the owner and the contractor that you're leasing equipment for a project within 30 days after the equipment hits the job site. If your contract is with the GC, you don't have to send notice to the contractor, but you still have to send it to the owner. But if your contract is with a subcontractor, then you've got to send owner to both the owner and the contractor within 30 days after the equipment hits the job site. And the lien statutes also, and again, this is in order to preserve your right to lien the project. If you don't do that, you lose your lien rights. The statutes also provide that an owner or contractor, if they request of a material supplier, you also have to notify them what the equipment is and to whom it was leased. Residential contractors, for you guys, in order to have lien rights, you have to provide a notice of lien rights to the residential owner and have the owner sign it. And if it's if two people, if it's a husband and wife who own the property, you have to have both of them sign the notice of lien rights. So these are just some of the deadlines and rules and requirements required in the Private Works Act, which is Louisiana Revised Statute 9:4801 et sec. That's what's known as the Private Works Act in Louisiana. And again, these are just some of the deadlines. This is not meant to be an exhaustive presentation on every single lien deadline and every single nuance of the statutes, because they are complicated and they are confusing. So again, it's important to consult with an attorney or SunRay Construction Solutions for help if you have a claim for a lien or possibly a bond claim. And just to add one other thing too, for the bond claims, there's still requirements, but you still have to send notice to the surety, and you have to do it in substantially the form that that your lien claim would have been in. But you do have 1 year from the lien filing period to actually file suit against the surety in order to perfect your claim. So that you do have a little bit of time when there's a bond involved. One other note, as I conclude, many subcontractors and even general contractors sometimes are a little skittish about filing liens or bond claims because they don't want to tick off a contractor or owner for whom they do work on a regular basis. But and I still get this. I still get people saying they don't want to do it. We're old school. We don't like to lien. But that mindset needs to change, because the law affords you, as important builders and contractors, people who are improving property, suppliers, that the law affords you lien rights to protect you. But in order to have what is already yours by law, you have to strictly comply with those lien statutes. They're there for a reason. Most people in the industry, including owners and general contractors, understand that liens are just a part of doing business, the same way as you might expect to get paid for your work. So don't be hesitant about filing liens. It's part of the way people do business, and it's to protect you. So on that note, it concludes the webinar. Does anybody have any questions?
So far, there is one question, and that one question was, how do we know if a final contractor's affidavit has been filed?
Yes, that's a good question. The answer to that is you've got to go and research the property records, because the property records, in order to terminate, to start the lien period running definitively, a contractor has to file a notice of termination or a notice of substantial completion in the property records for the parish where the project is located. And so that's how you would know. You have to check the property records, and if that certificate or notice of termination is filed, that starts your lien period. If no notice is ever filed, it becomes a little tricky. But there recently in 2020, they established some, prior to 2020, there was no, the lien, there was an argument and a case actually out of New Orleans that said the lien period never begins to run if no notice of contract is, no notice of termination is filed. But that was subsequently changed to provide a cap on it, which is 6 months for subs and 7 months for general contractors.
Okay, great.
Any other
And
questions?
there's one more question that just came in. And the question is, there's some confusion. If the notice of non-payment is 75 days from the last calendar day of the month, why is the lien deadline 60 days?
Yeah, I don't know why it's 60 days, but they're two different issues right there, right? So the first one is if you're a supplier, you furnished goods, materials to the job site, you have to notify the owner and the contractor that you're not paid 75 days after, within 75 days after the last day of the month in which you furnished those goods. And that the purpose of that is to afford an owner or a general contractor who may not have a contract with you, you have a contract with the sub, so they may not even know that you're on the job, but it's to afford them notice that, hey, my subcontractor hasn't paid you. And so you've got to send that notice, and that's what the law requires. It's basically 2.5 months after you furnish the goods. The lien is different. The lien attaches, it is a claim that attaches to the property, and that has to be filed 30 days after substantial completion if a notice of contract has been filed, and 60 days if no notice of contract has been filed by the contractor.
We have 2 more questions, and Ted, if there are any other questions from our audience, what we can always do is feel free. You'll see that our email is there, so we'll answer the next 2 questions. One of the questions is, what is considered substantial completion?
Yeah, that's a great question too. And so, typically the definition for substantial completion is that the project is sufficiently complete for its intended use, or the owner can occupy it. But in some cases, so that's the definition, and that's what, if no notice of termination or certificate of substantial completion is ever filed, that's what lawyers would be using to try to determine the date that it achieved that. But a lot of it, as you know, as everyone knows, is subject to the discretion of the architect, maybe sometimes the contractor and owner. But the determinative issue is it complete for the owner's intended use. Excluding things like punch list items and minor changes that need to be made. Does that make sense? Any other questions?
The other question, is there a specific is there a website that focuses on Louisiana lien laws specifically? And we have on our website, if you go to sunraynotice.com, there's the 50 states lien laws, and I could send you a link. But if there are more specific questions, we could certainly have Ted assist, because it's very specific. As you could hear from the webinar, it really depends what tier you are, what you're doing on the project. So it's going to be significantly different if you're a GC to a subcontractor, to a supplier, to equipment lessor. So the person that asked that, we're happy to further assist you on your process. So if you do have any other questions, feel free to reach out to us at any time. If you would like to take a brief moment, you could point your mobile phone to the QR code. We'd love to hear from you of what you thought about our webinar. It will just take maybe 5 seconds. I'll keep that up there. And then our next slide is our upcoming webinars. What happens after I record my lien? How do I get paid? Which is a very important question, because people think, oh, once there's a lien on the project, it's there indefinitely. And unfortunately, it's not the case. There's an action, the foreclosure, that has to take place. And the next one that we have is don't sign a release unless it says this one thing, on September 20th. So Ted, you did such a sensational job. We go to our final screen so everyone has your contact information again. That would be great. And if anyone needs anything, if you go, oh goodness, I forgot to ask that question, feel free to reach out to us at any time. And again, just a great job, Ted. And I wish everyone a sunny day.
Thanks. Thank you, guys.
Thank you.